Critical things families need to know about MDL 3047. The social media addiction lawsuit is a consolidated federal litigation involving over 2,300 claims against platforms like Meta, TikTok, Snapchat, and YouTube. Plaintiffs allege that addictive design features caused serious mental health harm to adolescents. Bellwether trials are actively underway in California as of early 2026, with executives including Meta's CEO testifying in court. What the social media addiction lawsuit actually is. The social media addiction lawsuit, formerly known as In Re Social Media Adolescent Addiction Personal Injury Products Liability Litigation, or MDL 3047, is one of the more historically significant pieces of litigation happening in the U.S. right now. It's consolidated in the Northern District of California, and as of early 2026, it involves more than 2,300 pending claims against companies like Meta, TikTok, Snapchat, and YouTube. That's a lot of cases, but the reason they're all in one place, one federal court, one presiding judge, is actually by design. The short answer for anyone new to this: a large group of families, young adults, school districts, and state governments have sued these platforms, arguing that the apps were deliberately designed to be addictive, and that this design caused real harm: depression, anxiety, disordered eating, sleep problems, and in some cases, far worse. The core claim isn't simply, "my kid used Instagram too much." It's that these platforms knew they were causing harm, had internal evidence of that harm, and deployed design features anyway because engagement drove revenue. That distinction between awareness and negligence is really what this litigation turns on. How an MDL works, and why this one is different. MDL stands for multi-district litigation. It's a federal mechanism for consolidating large numbers of similar lawsuits into a single proceeding. The logic is efficiency. You don't want 2,300 separate courts working through the same discovery questions, expert witnesses, and foundational legal arguments. Who is suing and why? The plaintiffs in the social media addiction lawsuit fall into a few broad categories. Individual families, parents who lost children to suicide and believe platform algorithms played a role. Young adults, individuals who spent formative years on these apps and now feel they were essentially trapped by design. School districts, institutions arguing that social media-related mental health crises have strained their resources. State attorneys general, officials who have filed related actions alleging consumer protection violations. These families watch their children spend hours every day on platforms that seem designed to keep them there. Not because the content was genuinely valuable, but because the apps were built to exploit psychological vulnerabilities. The companies knew their product was harmful, didn't adequately warn users, and prioritized profits over safety. A few themes run throughout the accusations. Algorithmic amplification. Platforms are accused of using recommendation systems that push progressively more extreme, emotionally stimulating content, because intense content generates more engagement. On Instagram or TikTok, that looks like notifications, likes, and feed updates that arrive at just irregular enough intervals to keep users compulsively checking. The platforms allegedly understood this mechanism well and deployed it deliberately. Concealment of internal research. Perhaps the most damaging allegation, echoing tobacco litigation directly, is that companies like Meta conducted internal research documenting these harms and largely suppressed or ignored those findings. Some of this research has since become public through whistleblowers and litigation discovery. Leaked internal materials, most famously the Facebook files published by the Wall Street Journal in 2021, showed that Meta's own researchers had documented harms to teenage girls from Instagram use. There's also the question of Section 230 of the Communications Decency Act, which has historically provided broad immunity to online platforms for third-party content. Plaintiffs have been careful to frame their claims not around the content on these platforms, but around the design of the platforms themselves. A bellwether trial in California in which a young plaintiff alleges that prolonged use of Instagram and YouTube led to addiction, depression, and related harms. No admission of liability, but a meaningful calculation. Early 2026. Trial continues against Meta and Google YouTube. The core question isn't whether teens use these apps too much. It's whether platforms designed them to exploit psychological vulnerabilities and knew it. What happens next, and why it matters. The social media addiction lawsuit is being watched for reasons that go well beyond the immediate cases. What happens next could shape how social media platforms are held accountable for years to come. These lawsuits aren't just about compensation, they're about responsibility, about transparency, and about protecting the next generation from harm that many families never saw coming. The outcome of this litigation could influence industry standards, corporate conduct, and the legal rights of parents nationwide. You don't have to navigate this alone. If your family has been affected, reach out to the Spencer Law Firm today. Get answers, get clarity, and take the first step toward accountability.